Hi, I'm Patrick Stegall. I'm a Memphis criminal defense lawyer. Today I want to talk about federal detention hearings. Detention hearings in the federal system are basically bond hearings. That's where somebody goes before the judge and the judge decides if that person is going to be released from custody before trial or if they have to stay in custody while they're waiting trial. The detention hearing is one of the first steps in the process. It happens shortly after a person has been arrested. If somebody is picked up by U.S. Marshals on an indictment or warrant, then they will be brought into custody and their detention hearing will happen pretty quickly after that. The attorney for the individual can request an extension, and those are frequently granted because you may need time. Me as an attorney, I may need some time to meet with the client and prepare for this hearing, but they're done very quickly after the person's taken into custody. And when you have the hearing, you're basically asking the judge to let you out, to set a bond for you to get out, and based on the evidence presented at the hearing, the judge will either grant your request and set a bond and let you get out, or will keep you in custody while your case is going on until it either goes to trial or it settles. So that's basically how a detention hearing works. What factors does a judge look at to determine if somebody should be released or not before trial? There are several. It can be the nature and the seriousness of the charge. Okay, that is a big factor. If it is a very serious crime, if it's involving trafficking guns or drugs, if it's a crime of violence, that's a factor that's going to weigh against you. That's something that the judge is going to look at and say this person could potentially be a dangerous offender and they should not be released. So if it's a very serious offense, that's going to be a check against you to get released. Other factors about you, your background. Okay, have you been arrested before? Have you been convicted before? Been on probation? Have you ever violated probation? Have you ever been late for court? Have you had a bench warrant put out for you for missing court in the past? Those are things that can weigh against you. On the flip side, if you have no prior record and you're a first-time offender, upstanding citizen, those are things the judge will take into consideration, and those can be positive factors for you. Likewise, if the crime you're accused of committing is sort of a lower level offense, not one of those serious offenses I just mentioned, that can be a positive factor for you. Your standing in the community, your ties to the community, if you have lived there, whatever county or district you've been charged in, if you've lived there for a long time, you have a home and a job and family support and things like that, those are things the judge will take into consideration. So if you or someone you know has been charged or might be charged with a federal crime and you're being taken into custody, first step you want to do is prepare for your detention hearing so you can give yourself a chance to get out on bond, and you may have to pay, you may have to post bond with the court or bail bondsman, or you may get released on recognizance, which you don't pay anything, you are simply released with certain conditions. Again, it all depends on the type of case and your particular factors. So the first thing you want to do is get an experienced lawyer on your side to work with you and prepare for that hearing, and that'll give you the best chance of getting out where you don't have to sit in jail while you're waiting for your case to go to trial. Again, I'm Patrick Stegall. I practice federal criminal defense in the Memphis area, and thank you for watching.